Okay, so we are back chatting about maintenance. Remember, I did say that it's not a must or a right to claim for spousal maintenance, but it is. You can request same, and the court will then have a discretion to grant. So you have to show that you actually do require this maintenance. Okay, that is now for spousal maintenance. The reason why this is so is previously when people were divorced, they were ordered to pay maintenance for the rest of their spouse's lives. The position has since changed, because now you can imagine, you marry one person and then you have to pay them R1,000 a month for the rest of their life, and then you end up remarrying, or you can't remarry because you can't afford it. You think, okay, I'm going to have to, in the event of a divorce, then pay this other person now as well for the rest of her life, and pay for her medical aid and all of that stuff. So the position then changed in Pillay versus Pillay in 2004. And the courts held that it was important for a clean break principle, so that both parties can move on from this relationship that had irretrievably broken down, and sort of relieve the parties of their obligations towards this person. But obviously you need to look at every case and ascertain what's going to happen based on the facts. There was another matter of Kruger versus Gross, where the parties got divorced. There was an order that the one party was going to pay the plaintiff spousal maintenance, and I think 60 installments, and only half had been paid, about 33 or so, when in fact the gentleman passed away, and then she claimed against his estate for the remainder of the maintenance period. So the remaining amounts that were supposed to be paid to her, she claimed for that, and successfully so. So another thing that the court would look at when determining whether maintenance, rehabilitative maintenance or spousal maintenance should be paid, they look at the age of the person, whether the person has a degree, is educated, the duration of the marriage, whether they have any kids, whether they are employed or in good health, and whether they're good looking, because the chances are the better looking you are, the better looking you are, the healthier, the more educated, whether you have maybe no children, the chances are of you moving on and finding someone else, the chances are then higher, right? So they look at all aspects. So in the matter of Coetzee versus Coetzee, the parties were married in 1997 out of community of property, excluding accrual, and they had been married for about 5 years. She hadn't worked for many years, and she'd been married numerous times. They were both quite elderly, so they both had children that were majors, and she was last employed like 22 years ago. Now, like I said before, what are the chances of now her receiving employment after 22 years? So he was ordered to pay her monthly maintenance, and it was he had to pay her about 8,400 per month, 80,000 rand for furniture, and all of that. So they really do look at the circumstances holistically. Okay, so with the clean break principle, this will allow people to move on from their relationships and enter into a new marriage if they so wish. In the matter of Botha versus Botha, this is also what I've been saying, is that neither a spouse has a right to maintenance, but the court has a discretion to grant it, and they have to show that they require it. It is very important that when you are consulting with your client, if there's a possibility that they will require spousal maintenance, but they might not be in a position to tell you how much now, or they think that they're fine now, but they are going to need it in a month or two, you would then put a nominal clause, nominal maintenance clause, maybe R1, because once that divorce order has gone through and you haven't claimed for spousal maintenance and the situation changes, you can't vary that, because then the obligation ceases to exist. So even if you put like a R1 for spousal maintenance, you can then go and amend it and all of that. However, after the order has been granted and there's no spousal maintenance, then you've lost that boat. Another thing that is very, very important is in your deed of settlement, once you've negotiated the terms of settlement and all that, to have a clause in there. It's a domkasta clause, to say that if the person who's receiving spousal maintenance lives with somebody else, in a relationship where, or being supported by anyone else, or remarries, that the maintenance will stop. So, for instance, if the court then grants rehabilitative maintenance for a period of 6 months or 2 years, and then you go and you get married a month after your divorce, if there was no order to say that, that person would have to keep paying maintenance, even though you're living with the person who is or married to this new person who is supporting you. You would still have to keep paying that maintenance every month until such time as the date is up, as per the decree. So that is also a very, very important clause that you would put in your deed of settlement. So please don't forget that. A lot of clients, when they come in, they ask us to assist them with the calculation of maintenance. They're not sure how much maintenance they're going to need for the kids. So in your notes on page 41, there is a calculation of monthly maintenance need, okay? And it shows rent, telephone, schooling, books, extracurricular activities, DSTV, all those expenses, and it gives you columns that you can complete. So this is the starting point, because remember that your kids might need more maintenance than the next person's kids. So it just depends on the standard of living, where they go to school, what they do, what their usual standard of living would be. So it's very difficult, to just say a 4-year-old needs 5,000 a month. It's difficult to say that, but if you can go through the form with the client and complete it, this is a form that you would complete if there is no maintenance order in place, that you're not going through a divorce or whatever. You've gone to the maintenance court, and you're going to be doing the application through there. This is this kind of application, but you can also use it to just to do a brief breakdown, to assist you in determining how much you should claim in your particulars. So it says self, it says child 1, child 2, child 3, and then total. So how this works is it's just a general form, a general way of trying to allocate how much electricity is spent by an adult and how much is spent by a child, and so forth with your expenses. Obviously, being an adult, I will use more water, I will use more electricity, I will use more gardening service or whatever. I'll use more. So what we do is you calculate 1 part per child and 2 parts for an adult. So for instance, if let's take one, let's take your even petrol. Let's take your petrol, because you are taking your kids to school, you're dropping them off, so they're also using fuel. Let's say it's 100 Rand for the month, and you have 2 children. You would then say, okay, it's me, 2 kids, but then another part adult. So it's 2 parts adult and then 2 children. So you work out 100 divided by 4. So that's 2 parts adult and one part for the one child, 1 part for the other child. And then you would see it's 25 for the one, 25 for the other, and 50 for you. Okay, so that is on your page 40. So then you break down and you work out everything, and obviously there are certain things there that that would only be for the adult, and there's certain things there that would only be for the kids, but the total would then ascertain how much maintenance you actually need. Okay, and then also to give a general understanding of more or less how much my contribution should be and how much my partner's contribution should be, there is a set breakdown of how you can actually calculate that. It's just a general something general that will assist you. It's not a hard and fast rule that you have to go about this. It is on your page 41. So you take the parent's gross income, the one parent's gross income, you divide it by both parents' gross income combined, okay, times by the child's needs. So if you say 3,000 Rand is what the child's needs are, divided by 1, that answer is going to tell you what that first parent has to pay. So let's say it's 20,000 Rand, the one parent earns 20 and the other one earns 30. You will then say 20,000 divided by 30,000 times, let's say the child's expenses are 3,000 divided by 1. That answer will tell you what the parent that earns 20,000 should be paying. And then you can also then you can obviously work out how much the other parent would be paying, or you could do the sum again and say 10,000, which is what the other parent was earning, divided by the 30 times 3,000 divided by 1 equals that, and that is what the 10,000 parent should be paying, just to give you an estimate. So that's how you deal with the maintenance issue.